The two main features of our system that reduce congestion are plea bargaining and pretrial diversion. I'll talk about pretrial diversion first. Pretrial diversion is used in a small number of cases. It's much less significant than plea bargaining. Pretrial diversion involves an agreement by the accused to admit responsibility, but not to admit guilt. The accused does not become a convicted felon, does not get a conviction. As a result, what they do is they enter into an agreement with the prosecutor, and sometimes a court official is part of the agreement, that says, I will do the following things over the next, say, 1.5 years, 2 years, and if I complete my side of the agreement, there will be no prosecutions. However, if you violate the agreement, then we may charge you. And one important part of that is that the offender agrees to waive what you call prescription period, what we call statute of limitations. So the clock stops ticking. Otherwise, what might happen is they violate the agreement, but the limitation period has passed, and there's no way for the prosecutor to then charge the case. The other technique is plea bargaining. And plea bargaining also involves an agreement between the prosecution and the defense. The prosecutor signs it, the defendant signs it, the defense lawyer signs it, and the judge approves it, typically. That is a major way of reducing our caseload. Over 90% of all cases in the federal system end in plea agreements. So only less than 10% of all cases are either dismissed for whatever reason or go to trial. The defendant will stand before the judge and explain why he or she is guilty. In some places, the defense lawyer will explain, the judge will ask the defendant, is that correct? Is that your statement? Do you adopt that? Yes. And the judge will then maybe question the defendant, make sure that it's knowing and voluntary, that he's not under any undue pressure or influence, not drunk, not medicated, etc. And then accept or not accept the plea agreement. Where the defendant recognizes that he or she is guilty, we give a benefit in the form of plea agreements. There are two main kinds of plea agreements. One is called the charge bargain, and one is called the sentencing bargain. So in our system, we have some flexibility built in that I think allows us to reduce the caseload and also to achieve due process. A related procedure that we have or feature of our system is what I call the cooperating defendant. In the Thai system, the prosecutor has a choice to either prosecute the accused or to make them a witness. In our system, we often have some middle ground where the accused will be a defendant, but a cooperating defendant. And in the plea agreement, there will be a section that says, I agree to cooperate fully, to do anything that the prosecution and the investigators ask me to do, to cooperate fully and truthfully. And if I do, the prosecutor will, and if I give substantial assistance, is the term we use, real help to the prosecution in prosecuting others, then the prosecutor will tell the judge about that. Typically, we will write a letter to the judge explaining everything the defendant did that helped us and how in considerable detail. So that defendant, that cooperating defendant, not only gets a reduction for accepting responsibility and maybe some favorable sentencing agreements by the prosecutor, but will also get a reduction for what we call substantial assistance. So for being cooperative, not just in their own case against themselves, but cooperating against others. one feature of the TIJ system that's a little bit like this, where there's an added benefit for cooperating against others, and that's in the drug laws. If a defendant testifies or cooperates against others, the judge may reduce, and there's some kind of statutory minimum sentence. There's always a maximum, and sometimes there's a minimum. The judge can then sentence below the minimum. So the minimum disappears and the judge can sentence below. If the prosecutor, the ONCB, inform the judge, this person has helped us against other drug traffickers. Well, we certainly try to group defendants together who are involved in the same case. So if we, in the US, we often use conspiracy law. And so I had a case, for example, where there were 11 counterfeiters selling counterfeit DVDs and CDs. And we could have brought 11 different cases, but we had a theory how they were all in a conspiracy. And so we linked them together. And then we had one trial. Joining defendants who are part of common criminal organizations and schemes is certainly one way to, I think, save court resources versus separate trials. Class action really to me is a civil concept, not a criminal one. So that is not a familiar concept in our system for reducing criminal dockets. In criminal cases, our judges have quite limited discretion to dismiss a criminal prosecution. You'll see motions to dismiss on constitutional grounds. We don't have a constitutional court, so the trial court can make a decision based on constitutional law. So I've seen, it's rare, but I've seen trial judges say, all right, this new criminal statute is unconstitutional. In criminal cases, judges rarely dismiss. They may punish certain conduct, sanction certain conduct by limiting the evidence that one side or the other may present, by limiting how many witnesses the government might present, by finding that a certain fact is established. But dismissal is an extreme and rare result. A big part of the court congestion here in Thailand is the result of having mandatory right of appeal all the way up to the Supreme Court. There was discussion in the last year about changing that so that there's not an appeal, what we call appeal of right, to the Supreme Court. But our Supreme Court doesn't take all cases. It takes 1% or less of all the cases that are offered to it by appellants from the courts of appeal. Your structure is different. You have a far bigger Supreme Court than we do. So, but as in many countries, it can take several years for an issue to resolve, and that's faster than in many countries. It can take a lifetime. But that's one possibility I know that Thai courts are discussing. At the trial court level, I would just refer back to my previous comments. To the extent that there's a lot of criminal cases on the docket, I think plea bargaining is a form of due process, and that saves prosecutorial time, saves the court time, saves the people's time and money. To me, plea bargaining, perhaps pretrial diversion, a more streamlined process for admitting guilt would be 3 ways at least to reduce the criminal docket substantially. Yes, cooperation, I guess, in sort of a tacit, implicit cooperation, but it's really, there are 3 parts to the system. The defense, having good defense lawyers who understand that a plea bargain is in the interest of their clients in many cases. So it's really a 3-sided system, but a key leg is that the judges have that the prosecutors have credibility with the judges, that the judges respect the recommendations of the prosecutor.